Welcome back to another edition of Meltzer Lippe Briefly Speaking. As always, I'm David Heyman, Managing Partner at Meltzer Lippe, a full-service law firm with offices located on Long Island, New York City, and South Florida. Just a reminder that this podcast and all our other podcasts are for informational purposes only. They are not legal advice, nor should be taken as legal advice. The only action that you should take after listening to this podcast is 1, to like us on your streaming and viewing platform, and 2, reach out to your Meltzer Lippe attorney for more information on our conversation. All right, so with that out of the way, guys, I'm delighted to be joined by 2 of my colleagues in the corporate group here at Meltzer Lippe, Alex Gayer and Tom Waldron.
Good afternoon, David. Happy to be here.
First time, long time. Excited.
So I know as much as we would like to discuss the Yankees, which is the better New York team, the Mets, the NBA and NHL playoffs, and of course the upcoming NFL season, we're going to be discussing something far more exciting today, and that is the life of an M&A transaction. So Alex, just real quick, what does M&A stand for?
M&A basically talks about the sale of a business. You could do it in either by a merger of 2 businesses together, or you have a buyer that would come in and buy the assets or equity of a business that wants to sell.
Great. So client comes in the office, Alex, and they say, hey, I've got my business. I want to sell it. I'm ready to be done. I want to sell it. What should I do?
Yeah, the first thing we like to tell a client in that situation is, you want to make sure that your house is in order, right, David? I'm sure you've experienced in the past. The client comes, maybe their books in order, books and records are not in order. That's something they want to make sure that they get cleaned up. Obviously, we can assist in that process. And you want to make sure that your financials are in order. You want clean financial statements. Things like that nature will help you maximize the value when you're looking to sell. You don't want to spook any potential buyers with having financial records that aren't in order. And that's something you should be working with your CFO and your accountants to make sure that you get everything as clean as possible to make the potential buyer, when they come and evaluate the business initially, they'll be very helpful.
So if you've been keeping your financials, let's say, on QuickBooks or an Excel spreadsheet or the back of a napkin, you're probably better off, Tom, getting an accountant to come in, putting in GAAP or at least tax financials so that you actually look like you know what you're doing.
That's right. GAAP or a modified accounting basis, at least as close to GAAP as you can make it. Those are definitely some main items you need to get out of the way. We call it reverse diligence, doing diligence on yourself. More important than that, or just equally as important as that, is a self-analysis. What do you want out of this transaction? Obviously, you're interested in selling your business. Why? Right? Are you, for instance, someone that's my age might have a little bit of a different perspective than someone that's David's age, just for an example.
Are you suggesting I'm older than you, Tom?
just throwing it out there randomly. But for instance, that plays into whether you want to be employed by the business going forward, whether you might want to stake in the business going forward through rollover equity or an earnout. These are all important things to think about before you start even finding a buyer or entering into negotiations.
All right, so let's take a step back. So clients come in, you say, you got to get your house in order. I like to use the analogy of the house. You want to sell your house, you paint it, you spackle the walls, you do little things. What, I guess, is getting your corporate house in order? We talked about financials. You mentioned reverse due diligence, or to use our sports analogies, self-scouting, right?
Yeah.
So what other things do you want to do, based your contracts, whatever, so that when buyers come in, I think, Alex, to your point, or, hey, it looks like we know what we're doing.
Okay. I mean, the easiest one, all corporations have a corporate kit. Oftentimes we see clients that haven't touched it for 20 years.
Unfortunately, that's true.
Yes, and it doesn't look too good to a buyer, so it's nice to have a clean corporate kit. Shows all the share issuances that have taken place. You have minutes showing elections over the years, maybe approval of some major transactions, things of that nature. That's a good starting point. Beyond that, you want to make sure you have your contracts in order, easily presentable. Obviously, it's good to know that they've been signed by both parties, the terms that are left on those things. And then as you get into the process more, you talk about assignability of those contracts and things of that nature. So having those presentable and in a clean format is very helpful.
Right, absolutely. To use David's self-scouting metaphor, if you have a huge hole in your secondary, aka you have a vendor that's responsible for 75% of your raw materials, but you need their consent to transfer it, it's better to know that early in the process than late when we're on the doorstep of closing and, oh yeah, we need to go get their consent. So definitely great to start that process early. Same thing with leases, with landlords, potential employment issues, getting union consent, tax issues, all things that need to be thought about far in advance to ensure the smoothest process possible.
So Tom, you just mentioned labor and employment, you mentioned tax. I find that the other analogy I always use is when you go to a restaurant. If you go to a nice restaurant, you want the plate of food to look nice. I never understood when I watched Chopped and stuff like that why they grade them on what it looks like, because to me, you can tell I care like what it tastes like more. But it's nice to have things look right. So part of that is understanding your tax issues, your labor and employment issues. Can you just expand on that a little bit, especially the labor and employment side?
Absolutely. So depending on what type of structure of the deal, like Alex said, there's a number of different ways to do M&A deals, whether it's a merger, an asset deal, an equity deal. You might have union issues that can pop up based on the transfer. Withdrawal liability is a potential issue that needs to be analyzed. We have a great labor and employment group here that can help look into those
Just
issues.
let me interrupt on that. Withdrawal liability is probably the biggest thing that's missed when dealing with a union. It's not necessarily what you think it is. You can be paid up on all your union dues, but you still may have a withdrawal liability. So it's very important, as Tom said, to speak to a labor and employment attorney who's well versed in withdrawal liability. So sorry, Tom, I interrupted.
No,
I say, and we're lucky to have that here, obviously.
Yeah, and the reason it's important to catch it early and to flag it early is we've actually had deals where we've shifted from doing an asset deal to an equity deal in part to avoid withdrawal liability issues.
And also, your tax issues come into play. You don't want to sell your business for $30 million and have a tax hit of $28 million. That's
right.
Not a good trade. Okay, so now, we clean the house, we clean the carpets, shampooed the rugs. I guess that's the same thing. Put the paint on. What comes next? How do we let people know that, hey, we're out there looking?
Yeah, based on our experience, we've been doing this a long time. We have a lot of relationships that can assist in that process. There are business brokers and investment bankers that we work with regularly. Oftentimes, a seller may have their own relationships in that regard as they're thinking about selling their business. But these are professionals that can help you generate bidders, potential buyers out there, which will obviously help maximize value. And they often prove during the process extremely helpful during the diligence phase and just keeping the deal on track. And so they're invaluable in a lot of these transactions. And there's other ways potentially that people think about when they're thinking about selling, that they're able to make that kickstart it.
Right, and Alex used the word relationship, and it's a lot of ways the relationship between buyer and seller is a relationship. It has its ups and downs, and hopefully it's you have a happy ending. But one other way that it's like a relationship is that sometimes it strikes out of nowhere. You're not even looking. We've had clients that they go to a trade show and it turns out that a large player in the industry is looking to expand, and we've had deals like that. So I guess same thing with most things. Get yourself out there, and that's how you could find a potential buyer.
So you mentioned investment bankers, business brokers. When in the process do you want to reach out? Get a business broker involved. What value what value add do they provide? You touched on it a little bit, but if you can expand on that, and why are they important to the process?
Very early on, I think, after that initial conversation with your counsel when you're thinking about it, obviously I think it's key if you can be planning well in advance. But when you're prepared to actually go to market, or you're going to market 6 months from now, to engage them at that point, I mean, they have a lot of insights. Obviously, they represent a lot of people who have done this in the past. Maybe even helping that cleanup and getting your house in order process as well,
Right.
to a certain extent. And then engaging them. There's a cost involved with that. There's a commission. You're going to get an agreement in place with them that will set forth all the terms of that, which is very important, which I know we've had experience where sometimes there's a fight about that later on. And it could be, a significant amount of money that you're dealing with,
Right.
based on the size of those transactions.
So, Tom, what does we hire our investment banker? Can you just briefly take us through the process that they use to gauge interest in the business? What offering materials they put together, pitch book, whatever, and how do they go about doing that?
Right. So it really depends on what their individual relationships are and kind of the size of the deal. But they'll prepare business diligence materials. They'll prepare a slide deck of what the history of the business, how it competes in the marketplace, and depending on who they're targeting, whether it's private equity, whether it's a strategic buyer, it'll be tailored to that. And I just want to expound on one thing that Alex said regarding kind of the value that they bring in addition to going and finding something. Like Alex said, they get their commission when the deal closes. So they're very interested in getting the deal to close, and they serve as kind of, one, a hand holder, but two, as a go-between. Emotions can get very high during this process, and like our role is to be the legal go-between on the sides. They can serve as a business go-between.
Great. And so now we've cleaned everything up. We're out there with our slide deck, our diligence site. People have kicked the cans. We get bids in. Now what?
You're going to take a look at those bids, analyze them based on who the buyer is. Do they have the funds necessary to close and consummate the transaction?
So, that's a very important point. You can get a bid in at X dollars, and you can get another bid in at X plus. But if David Heyman's one at X plus, I don't have the funds to buy it. So X is going to be a better deal because your likelihood of getting retraded is going to be less, and the likelihood of closing is much greater.
Right. Oftentimes the highest bid is not the best offer. No question about it. You want to see what the terms of those deals are too. Maybe a lower bid is coming in with an all-cash closing, which obviously can be very meaningful. So it's important to evaluate both the buyer and the terms of that deal. And there's a lot of different aspects to what that deal could look like that you need to look at. Obviously, we have experience to do that, and the professionals that we're working with have a lot of experience with that as well. So, we help the client analyze that and make a choice on who to go with.
Great. So, Tom, you had mentioned, I think earlier, asset and equity deals.
Mm-hmm.
Can you explain A, the difference,
Sure.
and B, when you tend to use one versus the other, or what the benefits and detriments are to each?
Absolutely. So
In 3 words or less. No.
3 words or less. I think I can do it in 1 word. Tax. That's the main reason you choose one or the other. There are other reasons
Right.
that I'll get to, but basically, an asset deal is when you're buying the stuff. You're buying, in law school we use the widget factory. You're
Right.
buying the widgets. You're buying maybe the factory if they have it, or the contract that lets you manufacture at the factory. In an equity deal, you're buying the stock. You're buying the company itself. There are benefits and detriments to either one. In an equity deal, you buy everything, including the liabilities. In an asset deal, the liabilities don't automatically travel with the assets. The reason why you would choose one or the other, like I said, mentioned at the top, there are tax considerations. Tax treatment is different depending on whether it's an equity deal or an asset deal. But there also could be issues like withdrawal liability that we mentioned before, or a potential issue with assignability of certain contracts as well.
Right. So if a contract's written, when I started, as you nicely pointed out early on in the Stone Ages, contracts would say you can't transfer the contract. probably, I want to say 5 years ago, it was probably more like 25 years ago, maybe 35 years ago, contracts started saying transfer means both a direct and indirect transfer. So that's a reason why, if you don't want to go get consent and it's written poorly, that you may do an equity deal over an asset deal.
Absolutely. Like we talked about before, and you do the initial reverse diligence and you find that, we have major contracts with customers or vendors that have anti-assignment clauses. Well, if those clauses don't include, like David was saying, indirect transfers or change of control provisions, then it might be beneficial to do an equity deal because we don't have to worry about going and getting a third-party consent.
Yeah, and another consideration often is licenses. Sometimes those don't need to be transferred in the equity context. And if that's a large part of the business, that's another, often can be a major consideration.
Great. Okay, so we got our bids in, we pick our winner, we start, you start negotiating an LOI, purchase agreement. Can you guys highlight some of the, bigger issues that come up in those negotiations?
Yeah, in the LOI context, the biggest thing from a buyer perspective will be to get an exclusivity. Which means that for a certain period of time, often 60 to 90 days, the seller will be prevented from going out and speaking to other people about a potential transaction. So that's the most important part of that from a buyer's perspective. But the LOI will also set forth, the high-level terms of the deal, purchase price, maybe employment contracts that are expected, other terms of the deal that, on a high level, often, just a summary half page that's kind of annexed to a pretty standard form.
And an LOI is non-binding. Usually there's language that it's not set in stone, right? You can still negotiate. But the amount of times a client kind of thinks, oh, well, it's non-binding, so I don't need to bring my attorneys in right away. I'll enter into this, I sign this LOI, and then they send us, hey, here's an LOI. I sign, well, what about X, Y, and Z? And you're in a bad spot. So by getting us involved early, even earlier than the LOI stage, but especially to review the LOI, it's not binding, but it is hard to deviate from the LOI because especially the buyer will say, well, that's in the LOI. What are we doing here?
Yeah, but that's right. I get to use one of my favorite lines. It's just the LOI. It doesn't mean anything. Not really, but sometimes you do have to use that. All right, so we have the LOI done. Who drafts the purchase agreement, buyer or seller, in a corporate deal? Usually.
Buyer's counsel.
Right.
Yeah, and a lot of people are not familiar with that. Tom and I had a meeting earlier today where we were talking about this very topic. You see it in the real estate deals. Oftentimes the seller's counsel is the drafter.
Correct.
So people make that incorrect assumption often. They're not familiar with corporate transactions, but the buyer wants to be the first, drafter, get their terms that they desire to have in the transaction. So it's important for us as buyers to do that, and we know as sellers that we have to react to that.
Right. And so, Tom, you drafting the contract. What are the, whether we're on the sell side, well, for drafting, we're on the buy side, but whether we're the buyer or the seller, what are the top 3-4 areas that are most often highly negotiated?
So I think one of the most important things, this goes back to, again, when the broker gets involved, in addition to the slide deck, I think David mentioned the data room. So that's all the diligence materials, all that stuff that you look through, all your contracts, that goes and that interplays with the agreement, the reps and warranties. And that can be negotiated on materiality and especially as it involves indemnification. And just to, to rewind, reps and warranties they're statements of fact about the business. When you have a buyer and a seller and they're third parties, there's an information asymmetry that exists between the two parties, right? The buyer knows less than the seller. The seller's been running the business. So in the agreement, there are statements of fact that we own what we say we own. Our tax returns have been filed on time. We don't have any union contracts, things like that. Just statements of fact that really, you need to negotiate because that really leads into.
So those are going to be statements of fact about the business, like you said. These are our contracts. These are our employees. We don't have any litigation, or if we do, everything.
Here are financials.
Here are financials. You have a disclosure schedule saying accept whatever.
Right.
So it's one of my biggest pet peeves in agreements that I see is, and you said a representation warranty is a state of fact today. One of my biggest pet peeves is where somebody says, I represent, warrant, and covenant. Covenant is that you'll do something in the future. I can't promise you the sun's coming up tomorrow. I certainly hope it comes up tomorrow. Otherwise, we got a bigger problem. But I can't covenant that the sun will come up tomorrow. So it's as silly as it sounds. To your point, you're going to get to it about indemnification. That can trigger a breach of of a rep, which then flows into the indemnification provision. So, Alex, you want to speak about indemnification?
Sure. So indemnity provision is a backstop to the reps and warranties that Tom was talking about. The seller and often the principals of a seller will have to stand behind those reps and warranties, and they'll make an indemnity to the buyer. And the terms of that indemnification are often heavily negotiated. You often have caps on the amount for the non-fundamental representations, if we want to get a little bit more technical. And there's often a deductible or a basket. So there's an amount of money which, unless there's damage occurred higher than that amount, that the buyer wouldn't be able to go after the seller for. So the types of those baskets and the caps and kind of the details around that are often heavily negotiated.
So I have a rep, I rep that these are my contracts, and it turns out there's another contract that creates a huge liability. Damage now to the buyer. That triggers a potential indemnification. Tom, Alex mentioned baskets or deductibles. There's a couple different ways that baskets work. Can you talk about that a little bit?
Right. So the first way and the pro-seller way, the way we try to include in agreements is a deductible. And it works just like an insurance deductible, where the buyer is responsible for the first, whatever the amount is, the first percentage of the loss until you hit a certain amount. The other way is a tipping basket, which is more favorable to buyers. It's the same. At first, it's the same. Buyer is responsible for the first amount of losses up to a certain threshold. You try to cover de minimis losses. And then once it hits that threshold, it tips over and the seller is responsible for the full amount.
Right. So if you have let's say a tipping basket of $100,000 and you have $101,000 of damages, the indemnitor is responsible for $101,000.
That's
Where
right.
if it's a non-tipping basket, it's $1,000. So that's why
Absolutely.
those are important. Right, go ahead.
One thing I wanted to mention in this context, oftentimes you have escrows that will cover these exposures, and that's something that's negotiated at the LOI stage as
Right.
well, which we didn't mention earlier. But the agreements often contain an escrow to address these liabilities should they arise.
Okay, so we talked about reps and warranties. We talked about indemnities. What other provisions in the agreement, should we let our viewers know about that are more of the important, let's say, non-legal things to think about, meaning dollars in the person's pocket or out of their pocket?
One thing we actually, Tom and I also spoke about this earlier. There you have purchase price adjustments,
Right.
so that happen post-closing, based on there's a net working capital consideration where the seller agrees to leave a certain amount of working capital in the business. There'll be estimates done as of the closing. That gets reconciled after the closing, usually 90 or 120 days after. The terms of that net working capital provision are very important when it becomes contentious. So that's something that we spend a lot of time and attention on to make sure that our client's in the
Right.
best position possible should that become an issue.
Right. So at closing, you'll say, hey, the company is X dollars to exist, your working capital, and you'll have a target. Let's say, pick the number, whatever it is. You don't have all the details at that date, so you guesstimate it, and then, as you said, down the road, you'll actually, when the final payables, receivables, what have you, come in, you'll readjust it. I'm sure that never there's a disagreement on that 60, 90, 120 days down the road, because everybody gets along just fine, right?
We see that in almost every deal where there's an issue around that, for sure.
And that's why it's important to negotiate the dispute resolution procedures specifically for that post-closing adjustment. Whether it's the right to object to the purchaser comes in with their number, making sure the seller has a right to object, making sure the time frame is long enough for the seller to really go through and confirm those numbers, making sure that it possibly choose an accounting firm in advance, one that we trust, one that's not affiliated with the buyer. Those things are all important to make sure they're in the agreement and are, as I was saying, heavily negotiated.
Okay, great. So one thing, if you guys could just touch on briefly, all sales are not the same, right? So in all consideration, everybody thinks, oh, it's dollars. It's not always dollars that are paid, especially private equity deals where a private equity fund is coming into the deal. They like to keep management on. So Tom, can you just talk about, how those deals work and some of the other issues that you have to think about in those types of situations?
Sure, and this is the bearing of fruit of what we talked about before about what you want out of the business. So and choosing the right buyer, as we also talked about before. As if it's a private equity firm, generally they pay 80% of the purchase price in cash and 20% via rollover equity. Rollover equity means that you become a member or a partner in whatever joint venture was buying the business. Now, depending on the deal, that's very important to think of what are you getting, who are you getting in bed with, what deal are you entering into? Because sometimes if you're on the top level, it could just be your company. Other times, if you're a little bit of a smaller fish, you could be part of amalgamated with 10, 20 other deals. And to take a step back, the reason that private equity firms especially like to do this is to align management with the growth of the business, with the continued success of the business. And sometimes sellers love that too, because they think, I have a really successful business. I think it's going to grow once we get this infusion of capital from a private equity buyer. It's going to just go gangbusters. They might want to be a part of it. The problem, though, is if you have 20 other companies, your business might be great, but you could have 19 others that aren't so great, and through no fault of your own, your investment could be not worth so much.
Right, that 20% won't be worth 20% anymore.
Exactly.
Or 20% of nothing is nothing.
Right.
Yeah, and another thing I've seen a few times recently, the exit of that rollover equity is not always crystal clear, and maybe not in alignment with the seller's expectations. So that's something we need to educate them about pre-closing, because all those LP agreements, the operating agreements, they're not all the same, and the exit rights definitely vary deal to deal.
Absolutely.
So I guess the last thing I just want to touch base on when it comes to a purchase contract is the non-compete aspect to that. There's a growing trend in this country against non-competes. Does that apply to an M&A transaction?
It doesn't. I think something that we were discussing before when we had our meeting with the Summers, there's a case, famous New York case from years ago, that involves the sale of a pizza place, and the judge ruled it so, and the guy sold his pizza business and opened up a new restaurant next door with the same name.
Bad lawyering.
And part of the case was that the non-competition is so fundamental to the business that generally courts have a very vested interest in people being able to be employed and earn a living. But what you're selling is kind of that non-compete. So non-competes are generally enforceable in the M&A context when they might not be in the employment context.
Great. All right. So now we've done a good job. Hopefully we've got all these things worked out. We signed the contract. We're going to close in 30 days, 60 days. It's on autopilot, right?
I don't think so, David. There's still plenty of issues that need to be kind of taken care of in the interim period, and things, closing conditions that need to be addressed. One thing, is often a key component is our employees. Sometimes we see employees that aren't even aware of the transaction at that stage, that have to be brought into the loop. And oftentimes, a buyer may want them to continue. They want the business to continue the way it had been operated, particularly in a private equity context. So there's still lots of work to be done in that interim period.
So that's where covenants come in, just to go back to my pet peeve. The covenants in the agreement will say, okay, we signed the contract. This is how you operate the business between now and closing. Because obviously, again, buying a house. I look at the house, it looks good. When I go to close, that's why you do a walkthrough, because you want to make sure, they haven't painted your walls black or, green and orange or something like that, unless you like that. But, well, I guess it was blue and orange. You guys might like it because it's the Mets colors.
It's my childhood bedroom.
There were some other things I think we had thought about in this, in that interim period that need to be addressed as far as consents and maybe some, the consents that we talked about earlier in that context. If there's governmental approvals,
Right.
things of that nature that need to be satisfied as
Right,
well.
so there's 2 governmental approvals that I can think of, if you guys could touch on those. One is Hart-Scott-Rodino, and just explain when that may come into play, and the other would be bulk sales tax issue. So Tom or Alex, whoever wants to take that.
Sure. So Hart-Scott-Rodino is an antitrust act that has a safe harbor under a certain purchase price. So it comes into play when it's a large deal, and generally there's a filing period, and there are certain exceptions where Hart-Scott-Rodino wouldn't apply. But generally, the idea is to allow a certain waiting period and certain time for there to be a antitrust review of the transaction. It's something that is on deals that are above a certain number. It needs to be at least a thought, especially deals with a strategic buyer where you're in the same industry, and antitrust could potentially rear its head.
Right, we see those in large deals. You see it, like, I think recently, I forget the 2 airlines, but even was a code share trend. I forget, I think it was like JetBlue and United maybe, or something like that. Here I go, and I'm gonna get in trouble again by I gotta say all the airlines, but where they thought it would tip the scales, competitive scales, right? And Alex, you want to talk about the bulk sales laws, because that's probably more applicable to more transactions than Hart-Scott is.
In New York State, there's a bulk sales law, and particularly relevant for companies that collect sales tax. And in order for a buyer to avoid successor liability for those sales taxes, there's a certain procedure that needs to be followed, including filing with the Department of Taxation at least 10 days prior to the closing. And if you don't comply with that, it's something that could be a gotcha down the road, right. Which if representing the buyer, you wouldn't have a very happy client if you didn't comply with that. And a lot of people are not familiar with that, right. Particularly when you're dealing with buyers from out of state. I've seen, right. In a transaction recently, a Colorado lawyer had no idea about it, and it's definitely a surprise to him when we had to discuss it.
Right. So what happens there is you send a notice into the state. The state comes back and says, yeah, no, they don't own sales tax, you're fine. They come back and say, you owe sales tax. The buyer says, okay.
They put some money in escrow and
right.
Deal with it.
Right, and if you don't deal with it, then it can be on the buyer.
Yes.
Going forward. Okay, so let's say we get all that cleaned up, we deal with the employment issues, contracts get worked out with key employees they want to keep on, all that kind of stuff. We close. We're done.
Or are we?
Okay, or are we?
Well, I think the thing that's important about M&A is, in comparison to some other legal fields, litigation, there's no final adjudication of a deal. There's no winning, there's no losing, there's no Super Bowl, which is lucky for the Bills fans here. There's no end in sight. It's really a new beginning at the completion of an M&A deal. It's 2 parties that were separate and now joined, and they're trying to run a business from really restarting.
I'll ignore that comment.
We talked a little bit about the purchase price adjustments. That's a post-close.
It would have been funnier if you said you are sitting to the wide right, but that's okay.
Oh, see, that's what I was talking about. I wasn't alive for the wide right Super Bowl.
It's all coming full circle.
Yeah.
Purchase price adjustments we touched on. One thing we didn't mention, if there's a deferred portion of the purchase price in an earnout,
right,
if there's a promissory note that needs to be paid post-closing, those are things that need to be addressed in the contract as well, and then it could rise to issues in the future that need to be thought about.
So just real quick, because I know we're running late on time, but you just mentioned deferred purchase price. One other way things sometimes are done is, we'll pay you X, but if the business performs the way we believe, what you seller say it's going to perform, we'll pay you if you hit those thresholds, which is another difficult drafting issue, because you, seller, don't necessarily have control over how the business performs after you've left it, right? And again, not that anybody would do anything untoward, but there might be some cooking of the books, so to speak, going forward. And we've seen that in the past as well, right?
Absolutely. And even if it doesn't go to cooking of the books, there's an adjustment period. So earnouts are generally over a 1 or maybe at the most 2-year period. And it's just really a short time period. Right. So as sellers, even if if we're advising sellers, even if they're really optimistic about the business and about the transition, definitely would prefer rollover equity and having a long-term stake as opposed to an earnout, because there could just be transition issues and onboarding new clients, things like that, that could take a period of time that might not be reflected in the earnout.
Great. So any final thoughts either of you have, Alex, Tom, that we didn't cover that you want to touch on? No is an okay answer, by the way. But,
I think we talked about the house selling of the house analogy. I think there are a lot of similarities. Obviously, in this context, they're more complex. It's important, to have good advisors, professionals, whether it be the bankers, obviously us as lawyers and accountants, to help you along the way, to maximize value, to avoid issues post closing, and obviously to get you to that closing.
Yeah, and I would just say that I've had it's a long process. It's a marathon, not a sprint. I've had clients say to me, "Tom, I've spoken to you more than my wife this month," and see, I'm not married yet. I should just steer clear of any follow-up comment.
I was going to comment on that. But,
on that one, but at the end, I will say it's worth it. This refrain I say often is an ounce of prevention is worth a pound of cure, and that's nowhere truer than in the M&A context.
Great, thank you. And I just want to echo that some people say, well, I don't have to get the lawyers involved, I don't have to get the accountants involved early on. That's the biggest mistake you can make, because, it costs you money in the long run, and it really does. So, listen, I want to thank you both, including you, Tom, notwithstanding your snide remark about my bills, but that's okay. And for sharing just a small portion of your guys' knowledge. Again, if you have any questions about what we discussed today, reach out to Tom, reach out to Alex. And until next time, I want to thank you all for watching and listening, and remember to like us on your viewing and listening platform. Go to our website, meltzerlippe.com, to find out more about the firm. And have a great day, and as always, go Bills.